These are your most basic rights that your lawyer might not tell you about. Number one, your case file belongs to you. So all of the documents that are in your file, the pleadings, the discovery responses, depositions, everything belongs to you. So all you have to do is ask your attorney for your case file. Under New York law, that file belongs to you. You can get it in digital format or you can get paper copies, whatever you want. The more that you know what's going on with your case, the better. Get the case file, look at it, study it, and find out what's going on with your case. The more proactive you are in your case, the better. Number two, the retainer agreement that you sign with your attorney doesn't bind you to the attorney. So you sign the agreement, you think you're stuck, you don't like your attorney, forget about all that. It doesn't bind you to them at all. You can fire your attorney at any time, including right on the day of the trial, you can fire them. You have that right. Your attorney does not have that right. So your attorney can't just say, we're parting ways. If you don't consent to the attorney withdrawing from your case, that attorney has to go to court and get permission from the court to withdraw as your attorney. You have the right at any time to fire your attorney for any reason whatsoever. Right number three, you have a right to know the case expenses at all times. So you can request an itemized expense of all the cases. Even though the law firm is advancing the costs on your behalf, this is really your money because at the end of the case, you have to reimburse the law firm for the expenses. So ask for an itemized list of every expense, look at the expenses, and make sure that you agree with them. You should know what the expenses are. The bottom line with any case is if you don't know what's going on with the case, that's not a good thing. You and your attorney are not doing a good job of working together because it's that law firm's responsibility to keep you up to date at all times. Now, what about settlements? Settlement is your decision, not the attorney's decision. So if the money is too low, you tell the attorney, I'm not interested. Your attorney should respect your decision at all times because you are the principal. Your attorney is the agent, which means the attorney works for you. You call the shots at all times. So even if you have a disagreement with your attorney, what you want controls, and what you want the attorney to do decides everything. Keep in mind one thing. The more engaged you are as a client, the more that you interact, the more you communicate with your attorney. But let's just say that there's a lack of communication. That is the number one problem that clients face with law firms, that you don't hear enough from them. You don't know what's going on. What you should do is ask for a sit-down meeting with the attorney. And if they blow you off or ignore you, you got a serious problem. And the one thing I can tell you, before you cut the cord with this law firm and terminate them as your lawyers, the most important thing is trust. Do you trust the attorney? When they tell you something, do you believe that it's the truth? Because if you're missing trust, if trust is lost between you and the law firm working for you, then it's time to find a new lawyer. So what happens when you do that? You terminate the law firm. Generally, that law firm can ask for a lien for their services at the end of the case. They can also get reimbursed for the case expenses by your new law firm. So believe me, it's a hassle. You don't want to terminate your lawyer unless you really feel trust is totally gone in your relationship with them. Those are my best tips that your attorney might not describe to you. If you like the video, please subscribe to our YouTube channel. If you comment, I'm going to respond. Please share the video, and I'll see you next time.